Hello, everyone, and welcome to One Civil Law. And for today's stream, we turn our attention once again to the ongoing Karen Read case, a case that we have followed with great interest. Karen Read is accused of killing her boyfriend by backing over him with her SUV, and the evidence against her leaves a lot to be desired, as we discussed in the first trial. The state's case basically falls apart at every possible turn, but, somehow not for just straight not guilty. I understand there's a juror interview that Turtle Boy conducted. So at the end of today's motion hearing, we will do a review of that. Maybe in a different stream, maybe the same stream, I haven't decided. But we're going to do a review of that either immediately following this or in a separate stream. We'll see how it goes. But either way, we're going to try to figure out what the jury was thinking, because that's always a positive. To discuss what the court is going to be discussing today, or at least what we expect them to be discussing today, we are, of course, tuning in for this hearing at 11 o'clock. Early in February, the defense filed a motion to get unredacted documents from the investigation into the death of Sarah Burchmore. Read is accused of hitting her boyfriend with her SUV. Her first trial, of course, ended in a mistrial because the jury doesn't know how to jury, which, juries sometimes do weird things. It's just the best system we have compared to any other alternative. It's the best we've got. What else do you want us to do, right? Last week, the state's high court ruled the charges should not be dismissed. We discussed that. Prosecutors say that Read, a former adjunct professor at Bentley College, and O'Keefe, a 16-year member of the Boston Police, had been drinking heavily before she dropped him off at a party. They then said she hit him with the SUV, which we found the evidence against that to be extremely wanting, with the solo cups and the leaf blowers and the all the things that we discussed, and the distorted video and the flipped video and the missing 40 minutes and Trooper Paul and Trooper Proctor and so many things that were so many issues. Defense portrayed Read as the victim. Yeah. Saying that O'Keefe was actually killed inside the Albert home and then dragged outside. I'm not sure they ever actually explicitly said that, to be quite honest. I mean, they certainly alluded to possibilities, but I'm never quite sure they actually explicitly said that, but my memory could be going. They argued that investigators focused on Read because she was a convenient outsider who saved them from having to consider law enforcement officials as suspects. I think maybe it was tunnel blindness and then convenience, right? I'm not sure it really started out as a conspiracy dependent on the girl. It probably started out as suspecting her as a reasonable suspect. If a spouse dies or a significant other died, the significant other is usually a prime suspect, right? It's not that hard to figure out why, right? So she's a reasonable suspect. And I think probably what happened, although maybe I'm giving them too much of the benefit of the doubt, I think what happened is they sort of latched onto her. They saw some early evidence that got that direction. They drew some early conclusions, prematurely, and then they didn't know really how to back out of that. And then it's just been confirmation bias after that. That's the good version. I'm not sure whether or not it was a conspiracy dependent on the girl as such, but either way, it's a miscarriage of justice. The defense claims that several jurors revealed to them the first trial the jury was in agreement she was not guilty on the charge of second-degree murder and leaving the scene of the crash. They wanted the charges dismissed, saying that trying against would amount to double jeopardy. We've discussed that. I say no. The Supreme Court of Massachusetts says no. We all say no. Incidentally, and no disrespect to Melanie Little, who I do like, and her chat, but I did notice that her chat, because I was watching her coverage of it, her chat was not having it. Right? Her chat was totally not having it with this double jeopardy verdict from the Supreme Court of Massachusetts. And I just thought that was interesting. It's interesting that Melanie and I, both lawyers and both reasonable people, we sharply disagree. But lawyers sharply disagree sometimes. I mean, otherwise there wouldn't be split decisions at the Supreme Court. Sometimes people disagree on the law. I just find it interesting, of course. And I hope Melanie's having a great day, of course. However, last week, justices upheld the lower court decision by denying the motion to dismiss. So we discussed that previously on all that stuff. And of course, one legal analysis named Michael Crone said they weren't surprised, saying the court had a delicate balance. The Supreme Court has made clear you don't want to coerce jurors who have a good faith belief in decision one way or another. I mean, there are a lot of legal issues on that. We've discussed it at some length. But yeah, so we're going to have a motion to dismiss. This is not an evidentiary motion to dismiss. Okay. The judge will consider the motion dismissed based on legal arguments. Oh, they mean they're not taking evidence for it. That makes more sense, right? I was like, what do you mean non-evidentiary? They just mean they're not taking evidence for it. So we're just going to take the states as given, the state's case as given, and can we proceed? And the problem here is on a prima facie case. Yeah, I think so. Now, I still think the judge should have dismissed at the end of the state's case because at that point, it's no longer prima facie. At that point, it's beyond a reasonable doubt. See, that's the thing, right? When the burden of proof changes, you have to change your analysis. So to initially bring charges, to initially, bring a murder case, all you need is the prima facie case. You just need probable cause, the same that you need to arrest, right? If you want to bring someone to trial, it's the same as arrest. It's probable cause. Probable cause is like 1 or 2 out of 10. It's not very much. Now, at the end of the state's case, once the state has completed all their evidence and they've rested, then the burden shifts to beyond a reasonable doubt because the state has to be able to prove by the end of its case beyond a reasonable doubt, right? Because the defense doesn't have to do anything. So there has to be enough evidence beyond a reasonable doubt to convict. And I'm like, no. So if the question is, should we dismiss for want of probable cause? I agree. No, we shouldn't dismiss for want of probable cause. Should we dismiss for want of being able to convict on beyond a reasonable doubt? I still think so, particularly given the evidence that was adduced at trial, right? The trial, yeah. So there's no way on this earth this motion will be granted. Of course, you know that. I know that. There's no way this motion will be granted. We all know that. No one is going to be surprised, but that's okay. All right. And let's see. Also, there's a hearing on covering motions relating to the dog attack and the Sandra Burchmore connection. So let's see if we can learn a little bit more about that issue. Judge Beverly Cunnan, scheduling order, says the court appearance is reserved for evidentiary motions or voir dire to determine what evidence or witnesses can be presented. Reed is accused of hitting her boyfriend. Reed's attorneys are moving to exclude the prosecution expert, James Crosby, who plans to testify that the injuries to James O'Keefe's arm were not from a dog. We read that motion. I thought the motion was not very well written. I didn't think the motion made the right argument. Some of you guys in chat were making better arguments than the motion did, right? So I didn't think the motion really proved its case. The defense seemed to be hyper-focused on the fact that they're not a doctor. And to me, it's like you don't need to be a doctor. Because the question, as I understand it, right, assume the question. Assume the question is merely, are these dog bite wounds, right? You don't necessarily need a doctor for that. Now, in order to know how to treat that, what to do about it, maybe you need a doctor, but are they fundamentally dog bite wounds? No, right? Someone else can testify to knowledge of that. In fact, a doctor may not even necessarily be particularly qualified, although depending on, their experience with dog bite wounds, maybe. But again, the doctor wouldn't be qualified because they're a doctor, right? The nature of their expertise, even if they're a doctor, would be from their real world experience. It would be from seeing dog bite wounds. So the fact that they're an MD would be kind of incidental, actually, in that situation, right? It's merely because I was working in the ER, seeing all these dog bite wounds. Well, why were you in the ER? I was an MD, right? That's why I was there. But fundamentally, the way I got my knowledge was not from medical school in this situation. Fundamentally, the way I got my knowledge in this situation is from seeing dog bite wounds and recognizing what they are. Well, it's like, well, if a doctor can do that, and they don't need an MD to do it, the MD isn't the thing that's helping them do that, then you don't necessarily need to be an MD. And the defense rooted their argument in the fact this guy's not an MD. And I'm like, that's the wrong argument. And some of you guys in chat are like, he doesn't have experience with dog bite wounds. I'm like, that would have been a much better argument, right? That would have been a much better argument. But they rooted it in the wrong argument. So I don't think it's going to work because I think they rooted it in the wrong argument. Crosby has a doctorate degree in veterinary science, but defense say he isn't qualified because he's not a medical doctor. For my money, that's the wrong argument. That doesn't work. Reed's attorney submitted an affidavit from their own dog bite expert, Dr. Marie Russell, who said Crosby's conclusions are defective scientifically and medically. Well, yeah, but at that point, it's just like, do experts disagree, right? Unless you can prove his guy's batshit nuts. But No, I don't think that's going to work. Just because one expert says so, probably not so much. Unless the expert is saying this guy is just doing pure snake oil. But that isn't really the expert. That isn't really the argument either. You're confused because you thought Massachusetts required an MD. It's not clear exactly what the judge's ruling on this issue is, incidentally. But I don't think fundamentally, that doesn't sound right. It doesn't sound right that Massachusetts, as a matter of its law, requires it to be an MD. Now, it may be true that the judge said it had to be an MD, at which point that'd be a really good argument if the judge had said that. But the judge, the motion didn't really illuminate that point. It didn't really illuminate that point. I mean, it kind of vaguely referred to it, but it didn't give exact citations from the record. It was a little vague on that issue. And so, yeah, there was like one pull quote from the judge that was provided in the motion where the judge sort of seemed to imply that an MD might be required. But for my money, the motion was thin on the point. Right? It's like, is this just a stray line from the judge, or was this really a holding from the judge? It seemed thin. So I'm not sure Massachusetts law requires it. I'm not even sure the judge requires it based on what was provided in the motion. And so if I'm not sure that it's what the judge required, it's not a good motion, right? If I can't tell from the motion itself, right? Teach me, right? If I can't tell from the four corners of the motion that this has been, the judge was emphatic, you clearly said this and this has been your ruling and here it is and all the rest, right? Unless you make that point, it doesn't really work. So my expectation is the motion will be denied. And based on what limited I understand about the situation, that would be correct ruling in this situation. But that's sort of my understanding of the situation. Karen Reed's attorneys seek Sandra Burchmore documents. In a new filing, Reed's lawyers say they're requesting unredacted documents from a Massachusetts state police investigation into the death of Sandra Burchmore. Okay. Burchmore was 23-year-old and pregnant when the police found her in her apartment. A former police detective, Matthew Farwell, has been charged with killing her and staging her death to look like a suicide to keep law enforcement from finding out they had a sexual relationship. Okay. The investigation into the death of Burchmore has involved many material witnesses in the Reed case. Yeah, that's challenging, right? I mean, yeah, you don't want to necessarily have infinite trials, right? So you got to kind of stall things at some point. So you want to, as a judge, be careful when you peek behind other curtains because you don't want things to get out of control for your own sanity. Plus, you want to remain on topic. All right. The issue here is not the death of Sandra Burchmore. And just because, that officer was involved in that investigation doesn't necessarily have anything to do with this case. Right. So, yeah, that's a precarious position to try to be in because the relevance is not readily apparent. Now, I understand what you're trying to do in principle. I get it. Right. As a defense lawyer, I totally get what you're trying to do. You're trying to fish is what you're trying to do. Right. You are thinking that these people are corrupt reasonably, and you think that there might be evidence of this corruption in this other case, which isn't an unreasonable thing to think. But the problem is you don't really have a basis for that. In fact, you just kind of, are putting two and two together. But unfortunately, in this situation, you're fishing. You can't make out a proffer. That's the problem, right? How do you make your proffer? How do you get to, I have a basis in fact to believe that there's evidence of corruption other than the fact that I believe that these officers are corrupt, and so it must be true. How do you make your proffer? And I don't know that they can do that. That's yeah. I don't think that's going to work. The investigation and death has involved same of the material witnesses. Okay. Yeah, that's not going to work unless they can make a proffer, unless they can make a showing that they have evidence to believe it's true. Unless they can make their proffer, the motion will be denied. So probably not. Other topics that come up at Tuesday's motion include a motion from prosecutors to exclude testimony from crash reconstruction experts, the ARCA thing, which is pretty hilarious. We read that motion from the prosecution wanting to exclude ARCA. I don't think so. And defense requests for more surveillance videos and communications relating to Proctor. So all those things are up and happening. We will see how it goes. But yeah, so the motion to dismiss will be denied. The motion to peer into this other case will be denied. The motion to exclude the experts will be denied. Basically, all the motions are going to be denied today. State and defense. Everyone gets denial today, I think, is basically the direction we're heading. You get a denial, everyone gets a denial, is the direction that this seems to be heading. We'll see how it goes. And we'll see if we agree with the legal basis based on the arguments, right? Remember, of course, as we're making decisions, to remember that you can only make decisions based on what's on the record, right? Which I know is hard for some of you guys out there, and I love you, but you got to remember that when you're in court, unless it's on the record, it doesn't exist, right? If it's not on the record, it doesn't exist. So we can only base our decisions based on what is offered in court, in the written filings, in the oral arguments, and so forth and so on. So, for example, when I say, that it seems to my mind that the veterinary expert by the prosecution should not be denied based on this motion, I'm saying that because of the written motion, right? I'm saying that because I found the motion to be weak. I found the motion to not really make its argument. I found the motion to be making the wrong argument. It's like, but that is not my problem that it made the wrong argument. My job is as pseudo judge is to try to make the best decision based on the arguments that are in front of me. Not other exciting arguments, these arguments. So when I say things like that, it's because, well, that's my best opinion based on what they presented. And we'll see if they make better arguments. Maybe they'll change my mind. I mean, oral arguments tend not to change judges' mind. They tend to be more formal, but every once in a while you get lucky, especially if your opponent bombs, but that's more on them than you, right? And I've said that before. It's like you can't win an oral argument, but you can lose, right? You can't really win oral argument, but you can lose. So if the other side makes an ass of themselves, that definitely goes a long way. But if you haven't already won on the paper, right, you're not going to win an oral argument, right? You win on the paper. Law is about paper filing back and forth. Oral argument is just the garnish. So you don't win the dish on the garnish. You lose the dish on the garnish, but you don't win it on the garnish. So that's the thing. Oh, thank you, by the way, for the gifts. I was in my own head there for a second. Thank you, Bluefish, for 20 gift memberships. Thank you, Snacks, for being a member for 15 months. Thank you, Bluefish, for being a member for 18 months. Alan Parker, thank you, as always, for your continuing generosity. Alan Parker, a longtime supporter of the channel. Very, very much appreciated. Thank you so much, Alan, for your continuing membership. And Someone Bloody Random has been a member for 11 months. The state's animal expert is not a veterinarian, nor an MDDO, and will be 1,000% excluded. We'll see.
Morning, Ms. McLaughlin.
Not based on these motions, but we'll see.
Good morning, Your Honor. Hank Brennan for.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
I will never get over this judge saying sidebar. I mean, it's that Massachusetts accent, but when that Massachusetts accent really comes out, it will never stop being funny. And when she says sidebar, It's like, well, yeah, okay. We're definitely in Massachusetts. That's fine. Are we at a baseball game together? Right? Things you hear at a baseball game. Sidebar. It will never stop being funny. We're back to the OnlyFan. OnlyFan? I missed. Yeah, OnlyFan. Yeah, we're definitely here for that hot OnlyFan content. 100%. You know it, baby. Yeah. We've had previously appearing on this channel have been Seal, Clock, Chandelier. Chandelier is still a favorite of the channel. Peace to Chandelier. We miss you. But OnlyFan, we definitely like OnlyFan too. Yeah, 100%. We will definitely come up with more lore about the fan and who the fan is having affairs with, because that's the way we roll here on the channel. Who is the fan sleeping with? What is the love triangle? These are the real questions.
All right, so what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at Mass Court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you said?
They'll have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement, and the order is right here, Mr. Clerk. All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number?
I do, just a second.
Okay.
What is the basis to object? We don't have it. If you don't have it, that's kind of part of the problem, to be honest.
I'm sorry, the opposition.
I mean, that's the only basis I can think to object by the
Defendant's
government
motion to
is we
compel
can't.
production of a forensically sound copy.
And if they
We'll
can't,
get
that's
started
kind of
in
the
the argument.
problem.
You can give me that.
506,
Great, thank you.
that's the response.
What other objection would you have?
Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Yeah, I mean, this seems like a gimme.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan, We met after court. Mr. Brennan told us that we did not need, we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present.
We heard this.
If all the information was a download from the
Then we got there, and it wasn't there.
Unnamed iCloud account.
It was deleted, which was sad.
As long as that was videotaped, we were fine with it.
Okay.
And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, et cetera. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video. Which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything,
oh dear.
He went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th.
My frustration as an attorney right now is palpable, is how bad my frustration is. Right? I mean, like, what do you mean? What do you mean you're still discovering videos? Oh, we deleted the video. Oh, we magically found it on another account. Right. Okay. So we deleted the video. Oh, no, wait, here it is. We found it. It's in a different iCloud account. We just discovered just now. 3 years later. Yeah, no, I'm having a difficult time buying that story, to be quite honest. That sounds like some bullshit. Also, of course, it sounds like a Brady violation because we're entitled to the evidence in the control of the government. And this is a government employee. This is a police officer. So it seems like Brady applies. But we're just now finding out about it. Yeah, my frustration as a judge is pretty palpable. Yeah, I'm not a happy camper.
So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And
oh my God.
It sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired...
That's worse. That's worse for that's worse for the government. Wait a second. No, wait, that's even worse, right? What do you mean you just discovered it on the department's file system, right? I mean, at least the detective iCloud account, I mean, if it's a personal iCloud account, I mean, that's a little bit more understandable that you don't necessarily know what every officer has on their personal iCloud account. I mean, there's a whole host of other problems with this, but like at least that part sort of makes sense, that you're not necessarily aware of what's on, your police officer's personal iCloud account. That kind of makes a little bit more sense. I mean, you have to know Brady, but the fact that you didn't know is a little bit more understandable. Now you're telling me it was actually on the government's computer system the entire time, and it took you 3 years to find it? What the hell? Where's my sanctions stamp? That's all I'm thinking about right now as a hypothetical judge. All I'm thinking about is, where is my sanctions stamp? Where did I put it?
officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's CPD
sounds suspiciously
video file
official.
system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata.
I mean, one would presume. Yeah, and one would presume we want the data and we also want the metadata to prove like when it was uploaded, when it was controlled, you know, for authenticity, to authenticate it. That would be helpful. Yeah, I mean, you know, okay, great. Sounds reasonable.
The data and the log files as well. And that's the key entirely to the audit trail that we're interested in.
Yeah.
Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion.
But I'm entitled, aren't I? What? Okay.
Which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for.
I mean, it sounds pretty simple. I mean, I'm not really seeing the complication here. It sounds pretty simple. Okay. What's the problem?
Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this?
That's a good question.
It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford, it was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there.
Yeah, I mean, that's not possible. I mean, because the defense can't give you originals because they didn't create it. They didn't create the videos. How could they possibly give you originals? Unless you think a forensic copy is an original, which maybe, I guess you could think a forensic copy is an original, but okay. But we don't have a forensic copy, so we don't even have an original in that sense. So yeah, how can the defense give you something we don't have? Because we can't get it from the government because they won't give it to us. Yeah, I don't know.
And then it was that same day that miraculously the Canton Police Department revealed that in fact it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory because the audit trail will tell us information that we won't otherwise have from the raw video.
Right.
How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files.
Yeah, I mean, it goes to authenticity. And it's Brady material. It goes to authenticity. Is this video authentic? The metadata can be used to help you to determine that. So it's relevant. It's discoverable. It's Brady. It's like, how many reasons do you want, man? I mean, what? Okay. Unless the government's position is we don't have it, which at this point I'm not particularly inclined to believe, incidentally. So if the government's like, we don't have it, at that point I'm like, I don't believe you. And I'm over the defense like, what sanctions do you want? Right? So, okay. Unless there's some specific Massachusetts case law that somehow controls the situation. So unless there's like some case on point that says for some reason I don't have to do this, that, you know, fair enough, I guess. But unless it's I don't have it, or let me tell you about this case that says I don't have to because reasons. It's like if there's controlling case law, I guess. But other than that, I don't know what else there would be. Okay.
The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible.
That'd be good.
And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Okay. Prosecution, tell me why you don't want to do this in a way that makes sense, please.
Seems like another effort to portray some type of injustice brought upon the defense that half the facts are left out of the presentation.
Okay, tell me what I need to know.
About reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later?
Okay, we've moved on to a new topic. Although to be fair, he did mention it, so points off, I suppose, for the defense for mentioning it. It's like we've already been down that road with the 3-year thing with it not on the server, right? So it's probably a mistake for the defense to mention it because then the prosecution gets the chance to rebut it, and we're off point. But let's move on to the new exciting documents that we do have.
Filed a motion making representations that weren't accurate.
Okay, in what way?
I no longer had the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately.
Okay.
And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence.
I was like, I'm sorry. I've moved on to other issues in my mind, counselor. Could you please clarify? At this point, I want to know 2 things. All right, or I suppose like 3 things. Like question number 1: is there a video on a server? Question number 2: is there metadata? If the answer to those questions are yes, then 3, on what legal basis do you not want to turn it over? All right. That's what I'd like to know the answers to right now. This background stuff is not really what I'm all about. I don't care right now. I don't want to know. I don't care. At the moment, what I want to know is, 1, do you have a video on a server that you control? 2, do you have metadata on a server that you control? 3, if the answer to questions 1 and 2 is yes, then on what legal basis are you not giving it to the defense? That's what I want to know right now. Can we get to those topics? That'd be more helpful for me.
And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to.
Well, there is now.
And the government would ask, or state police would ask for a download of a particular event, like the Sallyport area. He would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective.
Okay.
And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it.
Okay. I mean, fair enough, but I still want it anyway. I mean, it's not necessarily all right. So if your argument is that this video and this metadata, or more the point, the metadata, I suppose more in the video, if the metadata is no longer the original metadata, because it was originally on some server somewhere, okay, and it's no longer there, so the original metadata is gone. All right, fine. So you can't produce the original metadata. I understand, right? You can't produce what you don't have. I get it. But now you have metadata of a copy. Now, is metadata of a copy as good? Not really, but at this point, it is literally the best evidence, right? Best evidence rule. We want to get as close to the original as possible, right? We want to see the original document. We want to see the original video. We don't want to see a copy. We want to see the original thing, or as close to it as we currently have, right? It's the best evidence rule, okay? So if the best evidence you have is this copy metadata, it's not as good as the original would have been, but since I don't have it, it's literally now the best evidence. By definition, it's all I've got left. And the fact that you don't have the original, I can also use as a fact that you don't have it. It's like, I can use that fact too and be like, I don't have it. You guys suck. You guys are trash that you don't have the original metadata, but and maybe the copy metadata, maybe it provides what you need. Either way, who can say what this copy metadata would say? I mean, I don't know in the abstract, and neither do you. Maybe the copy metadata is such that it just cements the state's case 8 different ways, and it's just the best thing ever. It's possible, and maybe not that. But either way, it tells a story, or maybe it doesn't really tell us anything, right? That's probably the most likely scenario, to be quite honest. It doesn't really tell us anything. So maybe it solves the case one way or the other. Maybe it doesn't tell us anything, but can we look at what's literally the best evidence? Can we do that, please? Okay. All right.
And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked.
Yeah.
Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive.
Can we have the metadata, please?
But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy.
Cool. Can we also have the metadata, please?
You asked us to speak in the back room. The 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later, so we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually.
I don't know whether or not there's metadata would make me angry as a judge. It's like, what do you mean you don't know whether or not there's metadata? What do you mean you don't know? They want the metadata. What do you mean you don't know whether or not there's metadata? My frustration level is going up.
Know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today is, it'll be done by the end of the week.
Why does it take that long? What do you mean by the end of the week? Why can't you do it like right now? What do you mean by the end of the week? We're talking about a digital copy, right? With the metadata. How about like now? How about like right this second? Are you busy? What are you doing during lunch? What? Okay.
You want to make, I'd be heard briefly.
Yes.
Very, very briefly.
Take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that. It's pretty immaterial what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata.
Also, typically, yes.
Typically, it's called electronic fingerprint.
Unless you go out of your way to prevent that from happening.
Whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the...
October 24th, did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert, my understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. It's the metadata associated with all those things. It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it for them.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion.
You're not going to roll from the bench on that one? I mean, it seems like an easy one to roll from the bench. Like, okay, well, you know, if you're inviting the defense to come over with the system, then fine. Defense can send their expert over, and they're entitled to any metadata that they can get an access to, and they're entitled to any copy of any metadata relating to this information. Seems like pretty reasonable order, but you know. Okay, we're not going to rule from the bench today. Okay.
For Prohak Vici, I asked you before when Mr. Alessi joined us, you have a rather vague...
Yep, there's Runkle. Yep, there's Runkle, the Bailey indeed. We got Runkle on a laptop in the courtroom. That's cute. That's neat. Shout out Runkle. Love you, bro. You're a good guy. I enjoyed our stream last night with Runkle. That was fun. I mean, it was interesting because Runkle was saying how he wanted to be in the courtroom, but he didn't want to necessarily take Turtle Boy's place in order to do it. And so I guess maybe this is I don't know if that's his intent, but maybe this is Turtle Boy's way of like, well, you're in the courtroom now. I brought you with me. Maybe that's what he's going for. Yeah, man, we live in interesting times.
Cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that.
Right.
I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay, thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel? Thank you, Your Honor.
Okay, the next one's paper.
Maybe her brief.
Yes,
Maybe her brief.
yes, yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay.
It's not an
Why are you sharing thoughts? Like either you have an issue, either you approve it or you don't approve it. I'd like to share some musings now about whether or not this attorney should be allowed to practice in this court. It's like, okay. All right, what are your musings? Let us know.
opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right, and I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney, and that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case.
They probably talk to each other.
There is a
Seems reasonable.
record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case.
Okay.
That there's an ongoing, long-term, implicit mutual assistance and mutual defense that they've been a part of for a long time.
Okay.
Now,
And
the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that
what are you talking about? Like, what are you talking about? I don't get it. Right? I mean, okay. What is the problem legally here? What is the problem? All right. You said, for example, that that discovery that's been given to Reed, or you at least implied, if I understood, you implied that discovery that's been given to Reed has been given to Turtle Boy, who then has published that discovery. Okay, is the discovery subject to a protection order? If the answer to that question is no, then what the fuck are you talking about? All right. If the answer to that question is yes, then why aren't you here for a violation of the protective order? Right? How did Turtle Boy get this discovery? If not from the defense, right? This motion, there was a protective order. How could he possibly know these things if not for a protective order? Okay, well, if there's no protective order, then the defense can do kind of anything they want with it because it's theirs now. It's their thing. All right. So if there's not a protective order, then they can share it with anyone they want. All right. Can these lawyers choose to work with Turtle Boy's lawyers? Sure. Why not? Why not? I mean, there might be some mutual interest there. They have a cooperation agreement amongst themselves. Cool. As long as that agreement is furthering the interest of both of their clients, then, cool. Like, all right. So what are we doing here? What are we doing here? All right, this lawyer wants to represent both Kearney and Reed. Okay, is there a conflict of interest? All right, is that your problem? Do you have a conflict of interest? What is the nature of the conflict of interest? You're not saying there's a conflict of interest. You're just saying the court should take notice of the fact that they're working together. Well, what do I care if there's not a conflict of interest? What exactly are you asking me to do? At this point, all you're doing is just casting shade. You're just doing shade, and I'm not liking it. I don't like the shit. I don't like it. Like, what is your legal hook? What is your what is your legal hook exactly? I don't know. It confuses me. Do you have a legal argument, sir? Anywhere in here? If you have a legal argument, please let me know.
Given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated. It is curious that
I mean, that's, you know, a totally separate issue. And again, I've not looked into it in any depth. I have not and will not here take a position as to Turtle Boy's legal culpability relating to harassment. I've not looked into it in any real depth. And I don't like to opine just randomly in the dark. That's not really what I like to do. So, and I don't really want to look into it. I don't really want to look into it. I'm already deep enough into the Karen Reed lore, okay? I'm deep enough in Karen Reed land. I don't know that I also need to visit Turtle Boy land, okay? I'm in as deep as I want to go. I think this is as far as I want to go. So I'm just tapping out. I'm tapping out on the issue of Turtle Boy liability with relation to harassment or witness intimidation or whatever, okay? All I'll say is witness intimidation is bad, harassment is bad. If Turtle Boy did those things in a way that violates the law, then fine, punish him. That's what laws are for, okay? That would be fine, all right? And if he didn't do those things, then don't punish him because you shouldn't punish people when they don't break the law, okay? But like, whether or not Turtle Boy did or did not intimidate or harass anybody, I'm not quite sure what that has to do with either the attorney representing Turtle Boy or Karen Reed or anything else we're talking about. Are we currently in the case of Commonwealth versus Turtle Boy? Is that what we're discussing right now? Is that why we're in court today? Commonwealth versus Turtle Boy? No? That's not why we're in court? Okay, so why are you telling me about the harassment intimidation thing? I don't know. Why are you telling me in the context of this case? Why do I care within the context of the universe I'm currently in? Why do I care? I don't care. Why are you telling me things?
Relationship exists, and the nature of that relationship is not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case.
Well, that would have been great then. Why? Okay, but why are we talking about it later? If you think there's been a violation of protective orders, then that might be a really good base to exclude this lawyer. But like you're saying, we're going to talk about it at a future hearing. What do you mean we're going to talk about it at a future hearing? Right? If you think there's been a violation of protective order, then that's a problem. And that might be a very reasonable basis to exclude this lawyer from working both cases, because there's now potentially a conflict of interest, right? If you really think there's a violation of a protective order, then this other lawyer getting involved that might be a problem. But you're going to talk about it at a future hearing? What do you mean you're going to talk about it at a future hearing? Why aren't you talking about it now? Like, this lawyer should be excluded because of this protective order, and we think that the information is being shared in an illegitimate way, and we think that therefore represents a conflict of interest that, you know, is a problem. What do you mean? I don't know. Okay, what are we doing here? I don't understand. What are we doing today? As the judge, I'm thinking to myself, why am I here? That's the thought going through my head right now as a judge. Why am I here? Why are you talking to me? Why am I here? What is it you want me to do exactly? How about that? Can we start with that? What is it you want me to do? Do you want me to exclude the lawyer? Is that what you want me to do? No, you're just here to provide random musings.
And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case.
Cool.
And so inevitably, you have Attorney Betterow will be serving two masters. He will receive protected information in this case that is supposed to remain protected. And not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to.
Okay.
And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage, and I am worried, and I have good reason to be worried, about the privacy of our protected material. I have good reason to be concerned.
Well, I don't understand why you're not taking the stronger position then. Because, I mean, legally, it seems to me that you could just say we oppose it. And these are reasons that we oppose it, which are not completely illegitimate reasons. And then I'd have to, break off the finer points of ethics and stuff to really figure out what the rules are here. Although this is a pro hoc vice, right? So it's discretionary. So at that point, I'd be like, no. Right? If it's a pro hoc vice, it's discretionary. And as the judge, it's an abuse of discretion standard. So I don't really even need complex legal reasons. I'd just be like, okay, that's that. But just take the position, right? Just take the position if it's what you want. What do you want me to do? Do you want me to say no to the pro hoc vice? Do you want me to exercise my discretion and say no? Is that what you want me to do? If that's what you want me to do, just tell me that's what you want me to do. And then maybe I'll think about it. I'll be like, okay, there's some things here that seem a little bit fishy. And, that makes me a little uncomfortable. And since it's an abuse of discretion standard, how about no? How about no? You can't have this lawyer. That might be a very reasonable thing for me as the judge to do. But you know what you have to do? You have to actually ask me. You actually have to ask me. Why doesn't he want to make the motion? He wants the court to do it sua sponte? Is that what he's trying to do? He's like, I don't want to say it, Your Honor. I don't want to say I want to exclude it. But, if Your Honor wants to sua sponte, you're trying to make me do your dirty work for you? Is that what you want me to do? F you. F you. Have some big boy balls and take a position or stop talking.
About the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each.
I don't care. I don't care if the attorneys for Karen Reed and Turtle Boy are banging in a back room together. What the fuck do I care? What do I care about their deep and abiding relationship? What the hell are you talking to me about? Tell me something that matters, man.
And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case.
Okay, I understand that.
It doesn't.
Right, okay,
And
great.
that concerns the government.
Okay, great. Therefore you oppose it?
So while I do not object to Attorney Betterow.
Then what the fuck are you talking about? Why you don't object to it, right? It's like, what the hell? It's like, okay, you set me up, you tease me, and then you walk away. That's just wrong. You tease me and you walk away. That's not fair. I don't like that. I don't like that. Right? You have all these reasons that aren't completely illegitimate, right? We'll just assume that he's, making arguments that make sense, and this is true. But okay, I mean, this is a reason, we're a little bit suspicious. We're a little bit suspicious of this. We think that there's some bad pool going on. There seems like there's some improper information flowing. We're a little suspicious. How about no? How about no? But you're not actually saying no. You're just saying, well, we're not opposed. Then what the hell are you talking about? As the court, I'm thinking to myself, thank you for your random musings. I don't know why I listened to this. Can I have 5 minutes of my life back? That's what I'm thinking to myself right about now.
Many lawyers as they want. I think the court should have some caution and some concern. And should consider some type of inquiry ex parte.
The court, he's inviting the court to a sua sponte motion. That's what he's trying to do. I'm almost certain that's what he's trying to do because nothing else makes any sense. He's just trying to get the court to do his dirty work for him so that he doesn't like, oh no, it wasn't me who deprived the defendant of their counsel of their choice. No, I'm not doing your dirty work.
Without the Commonwealth present, about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Bedrow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again, it does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse, and that has not happened. For many reasons, it has not happened.
Okay, I mean, as to that much, I agree. Witnesses should not be intimidated. Witnesses should not be harassed. I agree with that. No objection to that. No one has a problem with that. Yeah, and to the extent that that has happened in a way that violates the law, then fine, prosecute them. And if they're guilty, then sentence them accordingly. That's fine. You shouldn't harass people. You shouldn't intimidate witnesses. It's obstruction of justice. It's bad. Don't do the bad thing. Okay? Don't do the bad thing. We all appreciate that. But, you know, what are we doing today? Right? What okay.
And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial.
I mean, strictly speaking, no, the defendant is not entitled to another attorney. The defendant is entitled to a competent attorney. Like, that's what they're entitled to. So you could just say, no, we don't want this. This sounds bad. We don't like it. It makes us feel weird inside. Right? It's an abuse of discretion standard. The judge has a lot of latitude. So you actually will get kind of far with it makes us feel icky. Now, you need a little bit more than that, but, you know, strictly speaking, not much. Then it makes us feel icky. Right? Because it's an abuse of discretion standard. The judge has a lot of latitude. And so, but, you know, actually take a position. Okay.
And the witnesses are entitled to walk in this courtroom without being abused.
That much is true.
Thank you.
Great, thanks. Let's give a slow clap. For whatever that motion was. Thank you for your pontification. The court is duly noting it. The court is thinking about what it wants to order for lunch rather than anything you just said, but, you know, that's fine.
Ms. Giannetti, I have to consider everything that was just said.
No, you really
I'll
don't.
wait for your affidavit.
Right. We'll try to address those issues in the affidavit, Judge. Thank you.
Okay.
The judge, it sounds like the judge is actually like contemplating doing this. And like, it's such, I don't even know what to think about this at this point, right? I don't know what to think about this. It's like the judge is willing to do the dirty work herself. She's willing to be the executioner. It's like, okay, you know, all right. What can you do? What can you do? I guess that's disappointing.
The next one, I believe, is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recording.
There's Emily D. Baker. Shout out to Emily D. Baker. Now, if uncivil law makes an appearance on this laptop, I will be surprised because Turtle Boy apparently doesn't like me, or at least I've been told. So we'll see if uncivil law makes an appearance, and if so, whether or not it is critical of uncivil law. Yeah. I mean, Turtle Boy is obviously doing something very performative here, right? And it's like he's trying to make a point. I'm not exactly sure what the point is he's trying to make exactly, but he's trying to make a point. Maybe he's just trying to give these creators some press. Maybe that's what he's trying to do. But the whole thing is amusing. But shout out to Emily D. Baker. Fire.
In possession of Gretchen Voss and/or Metro Corp. Relatively straightforward, but I'll hear you.
He wants people to watch the commentary to be better informed. Yeah, maybe that's what he's trying to do. Maybe he's just trying to give a shout out to these creators in the hopes that someone will notice and people will go watch those channels. So, fair enough. Maybe that's what he's trying to do. Just bring attention to the coverage of this thing so people will wonder who those people are. Maybe. We'll take the press. We'll take the press. It's good. I still don't think it's really appropriate for the courtroom. It seems questionable at best, but that's what we're doing now. Okay.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in effective order.
Maybe he thinks the law tubers are making better arguments than the lawyers in court. Well, sometimes. I mean, but to be fair, it's easy to have a lot of people looking at things and have different ideas about different things. No attorney is going to get it perfect 100% of the time. I'm sure that if I were in court, people would be poking me apart in every possible way. And when it's different to play the game than to, critique the game, which is always true. So, but the prosecution's saying things is like, okay,
beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay.
The case against Karen Reed should absolutely be dismissed. The state's case is shambles. It continues to amaze me to some degree that they bring this case at all. Given the evidentiary problems, given the problems with discovery, we're still somehow finding out about 3 years later all these issues that the state is actually bringing this case. This case is a wreck. This case is a disaster. But apparently some members of the jury were convinced by it. We'll be doing a reaction to that probably early this afternoon. I think I've decided to do it in a separate stream for the sake of convenience. So we'll probably take like an hour break and then do a reaction to the Turtle Boy interview with the juror. And we'll see how jurors think and become frustrated by it, is my understanding from other people who have watched it. It's like, yeah, jurors don't know how to juror. Apparently the juror said things basically to the effect of, for example, they just discounted all the defense experts. They didn't pay attention to any of the defense experts. It's like, well, that's exciting news. Okay. So we'll see how jurors juror, and we'll go from there.
No objection to this, is there?
No, Your Honor.
Of course, I'll provide the defense copy if they want.
Yes. All right, so this is allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from Attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today, and today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us, and I would ask that the court take no action on this motion until we've had a chance to view them, and we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested.
Understood.
Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first, or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has a wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses, and that's what we're asking the court to reconsider. It is our position, Judge, that part of, and I believe I quoted a case on the last page of the motion. The effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data which revealed that that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure, from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident. which, you know, we question what was done behind the scenes to, you know, arrive at that conclusion as well. And, you know, I also, you know, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed, so I take responsibility for everything that's in there. But, you know, we also make the point that with regard to, you know, Trooper Proctor, it appears as though there was, you know, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well. You know, if we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but, you know, this is a, I won't say unique trial, but it's a rare trial that, you know, is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with, and to the extent that we turn over this impeachment material and the Commonwealth uses it, you know, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward on cross-examination. So switching to the Commonwealth's motion for sanctions.
You know what, let's wait. When I said both, I thought you made 2 points that you made both 2 points.
Understood, understood.
All right, so, Mr. Brennan?
The court should enforce reciprocal discovery. You should enforce it, Your Honor. Trial by ambush is simply...
Oh, should enforce. Should enforce, not force. It's like, okay.
that trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control.
Yeah.
So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything.
Yeah.
If the Commonwealth is not going to call a witness, they still have obligations.
Yeah.
And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense.
Do you really?
Because it's in my possession, custody, and control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it.
Okay.
And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos, it's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay.
I mean, this is going to turn on Massachusetts specific rules, as he sort of alluded to. Different states are going to have different rules on this issue. Federal rules are different on this issue relating to discovery. So I'm going to try to extract what I understood from the discussion about the rule. So basically, of course, the Commonwealth has to disclose everything it knows that would either indicate the person didn't do it, would mitigate their liability or responsibility in some way, decrease the punishment, or would be impeachment evidence against a witness, right? They have to disclose everything they know relating to that, whether they call that witness or not, right? Because like that would be like, oh, I have there's this witness who can provide an alibi that I somehow know about, but I'm not going to call the witness, so I don't have to turn it over, right? That would be a really dumb rule. The Commonwealth has to disclose everything that it knows that fits into those categories. Okay, cool. As he explains the rule, the defense has an obligation to disclose any witnesses it's going to call. So it doesn't have to disclose information relating to witnesses they're not going to call. But if they're going to call a witness, they have to provide the information that they have relating to those witnesses, who they are, in the case of experts, the reports they've relied on, and the basis of their reports, and so forth and so on. And apparently, he says impeachment evidence is also anything they would know that would tend to undercut those experts or undercut those witnesses that they're aware of, that they would have to disclose. So, like, okay. So, assuming that's the rule, then this case is special, though, doesn't work, right? This case is special. Well, no, it's not in that respect. It's being filmed. It's being broadcast. People are commenting on it. So what? Like, follow the rule, right? So, I mean, maybe the rule is dumb because, as the defense sort of points out, it might give the prosecution an opportunity to have their witnesses conform their testimony. So maybe the rule is dumb, but that's another problem for another day, right? The rule, if that's the understanding of the rule, then follow the rule. Because, the witnesses would always have an opportunity to conform. This isn't a this case problem, right? This wouldn't be a this case problem. That would be an every case problem. Every case, right? If they turn over material, every single case, the witnesses would be able to conform themselves. So this is a universal problem. There's nothing special about the case in this respect. So, assuming he's describing the law correctly, then, the defense has to provide that information. So this sounds right. And the defense's argument sounded kind of more like this case is special and reasons. So the prosecution's argument sounds more grounded in the rule based on what I'm hearing.
Was there any follow-up?
Rule 14 does not require impeachment evidence, only standard rule of the court. Okay, fair enough. So the rule does not require it, but this judge is requiring it. Interesting. I have questions. If the rule doesn't require it, but this judge is just doing it, does the rule allow for it? Is it discretionary? Like the judge can do it? Or is the judge just making stuff up? At which point, that seems like error. Yeah. So, like, does the rule allow for the judge to do it, or is there a case that allows for the judge to do it, or is the judge just making up exciting new rules on their own initiative? Which always makes you wonder if that's okay to do, right? Judges sometimes have to make up exciting rules But, every time they do, you always are asking the legal questions like, wait a second, is that okay or not? Because obviously, anytime you're trying to do something that's not precedential, right? It's like, well, I have questions. Yeah. Yeah. So I have further questions. But he cited the rule. The prosecution cited the rule. The prosecution said this was rule 14 whatever, right? He said it was the rule. Now I'm even more confused.
To that, the motion for sanctions will be a little bit later.
Right. The only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was
It's
sort
discretionary?
of a rolling discovery
Okay.
that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
You're not doing a very good job on that, as the Commonwealth, I have to say.
Comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed.
Let's take a quick look at this thing. Thank you for my mod, A. Hedinger, for pulling this up. Let's see if we can figure out what they're talking about. Effective March 1st, the rule will be superseded, which makes me interested. As a judge, that makes my life a little bit more complicated. Because, which rule am I supposed to apply exactly at this point? All right. So I'm not sure exactly. We'll apply the pre-March 1st rule, I guess. So for the moment, right? So what did he say? It was, okay, automatic discovery, mandatory discovery for the defendant. Okay, we know that. Reciprocal discovery for the prosecution. Following a Commonwealth's delivery of all discovery required pursuant to subdivision rule or the court order, and on or before a date agreed to the parties or in absence of an agreement, the defendant shall close the prosecution and permit the Commonwealth to discover, inspect, and copy any material and relevant evidence discoverable under subdivisions A1, A6, 7, and 9. Okay, so now I have to read A1A, 6, 7, and 9. Okay. All right. So 6, intended expert opinion evidence other than evidence that pertains to defendant's criminal responsibility and subject to subdivision B2. Such discovery shall include identity, curriculum vitae. So expert data. That makes sense. Material and relevant police reports. That's interesting. The defendant has to disclose police reports. Where would they get them from is a really interesting question, right? Except from the government, right? But okay. So they have to disclose police reports somehow. I guess photographs, tangible objects, all intended exhibits, fair enough. Reports of physical examinations of any person or scientific tests or experiments, and statement of persons the party intends to call witnesses. So any prior statements that person has made. Fair enough. So if the prosecution, okay, so if they've taken, all right, that makes sense, I suppose. And disclosure of promises, rewards, or inducements, which again, for the defense, I'm not 100% sure what that would be, except money, but fair enough. Including the names, addresses, dates, and statements of birth, or statements intends to call as a witness. Okay. So it doesn't sound like, yeah, because exculpatory is like 3. Any facts of exculpatory nature doesn't seem to be included. Yeah, so I don't quite understand the basis of the judge saying, give me to the defense saying, give me impeachment evidence. But okay, that's apparently what the rule is. So interesting.
A motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with...
I'm sorry, before you do, so you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or?
Yes, of course,
Okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions.
That's exciting.
Or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if it's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations.
You tell them.
We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentional.
That feels like that's begging for a case citation, and I feel like there's got to be one, right? That just feels like it begs for a case citation, right? Because you got to know that issue's come up somewhere, sometime, in some case, probably in Massachusetts or in the federal circuit or somewhere. Like you can cite that proposition. But like, yeah, it's like basically like, oh, it's like the police know something, but they're not going to put it down in a report, so they have nothing to disclose. Yeah, but they actually do know about it. And somehow, yeah, there's got to be a case that says that, right? There's got to be a case somewhere that says that. So my only critique here is that sort of feels like it begs for a citation. And there's probably a Massachusetts case or other controlling authority on point, I would imagine. But you take what you can get. So maybe it's in the brief, and she just doesn't want to bring it up here. That'd be fine. But it does feel like it begs for a citation.
Its obligations under Rule 14. We're asking that this request be allowed.
She's good.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Burchmore. There are certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Burchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Burchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Burchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Burchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Burchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Burchmore. No evidence of improper conduct. Nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Burchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was a cadet in the Stoughton Explorers program.
That's less than ideal.
Violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is.
Okay.
This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects.
Okay, so that's an interesting argument. So let's parse that for a second. All right, so let's, to the extent that we have an expert who, in the other case, basically said there's nothing here, and then the feds said actually tens of thousands of messages. What are you talking about? Then that raises questions as to their ability to be an expert, right? because it's like they missed quite a lot. They missed quite a lot as an expert, so they're not very good at what they do. Okay. All right. So you want to try to bring that into this proceeding. It's the problem I'm trying to solve in my mind is, I don't want this to become the litigation of the Burchmore case, right? That's the problem I'm trying to solve as I'm sort of contemplating this. Because this case is about Karen Read, as it well should be, right? And I don't want this case to become a mini trial about Burchmore. And that's the thing I'm trying to avoid as I'm trying to figure out what to do here. So if I were going to allow this as a judge, it would have to be exceptionally narrow, probably, right? It would have to basically be like a very, very small part of the presentation, right? It would be basically like just a cross-examination question or maybe a follow-up, but you'd have to really contain this if you're going to go down this road. So it's an interesting argument. I don't know. And also, to the extent that you could make the argument from within this case's four walls, I just want you to do that, right? So if you could be because the question is whether or not they examined this data correctly, not whether they examined the Burchmore data correctly. And so it's challenging at best. If there's a way to, within this case, basically based on its own merits, say you didn't examine the data correctly or you're bad at your job, if you can impeach them within the case, that'd be preferable. So, but she's making an interesting argument. You'd actually have to think about it, but there are definitely counter considerations to be had here. Yeah. That officer didn't hit Officer John O'Keefe. There's no nexus. Okay, then you fundamentally misunderstood everything I just said. So try again, but thank you.
As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking.
That's cute. Right. That's cute. I like that. I like that. Turnabout is always fair play. That's always nice. So anytime you can use the opponent's words, or even better, the judge's words, is great, right? So it's like, it's not me saying it, it's my opponent, or it's Your Honor who said it, is even better. So like, yeah, we just literally copied their motion and turned it back to them in another witness, and now they're whining. Nice job. Good job.
For are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked the chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to.
I mean, I guess fair enough, although of course that presents its own problem, right? It's like we don't have the logs and we don't have the chain of custody, so we can't give it. Yeah, I have questions. Some of those questions are authenticity. How do we know the video is authentic without a chain of custody? Right? Yeah. The fact there are no logs, that's kind of the problem. How do we know who touched it and when, and under what circumstances, and using what tools, and how it might have been changed or modified? I have questions relating to authenticity. Yeah.
I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Burchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists.
It is tangential.
Throw out a name and attach it to the Burchmore case. Troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it.
He's not wrong.
A factual basis, a good faith basis.
He's not wrong.
We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it.
Fair
And so
point.
you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith.
I mean, he's spitting some reasonable facts here, right? The defense does have to have a good faith basis to try to do this. As I said, like at the start of the stream, I was like, you got to make your proffer. You got to have a good faith basis. You got to make your proffer. You got to have a reason to look. You can't go fishing. And he's fair, and when he says, like, the defense just said that, you know, there's nothing to see here, but they're not quoting from a specific report. They're not relating to any findings. They're just making some vague allusions about a case that is tangential. And, you know, that's a pretty good argument.
Basis because they want to entertain our audience. And so the reality is the Burchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Burchmore was a victim.
Yeah.
Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Burchmore case. Why?
Exactly.
Why
Fair
that
point.
case?
Fair point.
Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case?
He's not wrong. He's not wrong.
But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5.
Yeah. I mean, you got 403 problems out the ass, right? You got 403 problems out the ass in terms of this kind of evidence. It's substantially more prejudicial than probative. It confuses the issue. It leads to there's reasons to exclude this, man. It's like, yeah, if you want to try to bring in stuff relating to a different case, in this case, it's like, you know, yeah, he's not wrong. He's not wrong. The request makes me nervous as a judge. It makes me request. It's like, I don't want this to become about the Burchmore case. I don't want the jury inflamed by the Burchmore case. I don't want them making a decision in the Karen Reed case based on the Burchmore case. You know, I don't want them being inflamed by that and making a decision that's based on that. That's not what I want. I want them to make a decision based on the Karen Reed case. So this request makes me incredibly nervous. It's like, it makes me incredibly nervous. It's like, I got 403 problems out the ass trying to, assuming I can find relevance. So it's like, even assuming I can find relevance, I got 403 problems out the ass in my view. Because it's just off point, it's off topic, it's too inflammatory, etc., and so forth. And like, no. Yeah, I mean, he's not wrong, man, for making these arguments.
Communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense, so we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel, in view of the Commonwealth's responsibilities under Brady v. Maryland and Giglio, that most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the Department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024. Please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there's a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through.
New donation from Blue_Fish.
Thank you, Bluefish, for the donation.
And text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week. And I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right.
Okay.
Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right, so I'll take that under advisement. Do you?
Yeah, I think they're going to lose on the affiliated case. As to the other material, you know, we'll see, but I think that's too challenging. You know, yeah, it's just too challenging. You don't want the case to become about other things. You know, it's definitely possible, you know, to have an expert witness impeached by their own like past errors. So it's definitely possible, but it's like It makes you extremely cautious as a judge, as it should, because you don't want to become about other things. So, yeah.
You have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're over 500 at this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case.
Are you sure?
But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert.
Okay.
It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now,
well, they can only disclose what they have, and also what is it do you think that they can only disclose what they know? And what is it that you think, what are you talking about? I'm confused.
At the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request.
Okay.
It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial.
Okay.
And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it.
Okay.
We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government, and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed, and over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcript.
I'm very confused by this. It's like they gave you discovery of everything they have, which is all that they could ask about anyway. They don't know anything else other than that. So they can only ask the experts about the things that they know about anyway, and the expert only provided reports relevant to this case. What is it exactly that you think the defense needs to produce that can't? What exactly are you? I'm confused by this entire request. I don't understand it. It confuses me. I don't get it. I mean, it's weird for the defense to call an expert without having any idea what the expert's going to say. That sounds like a really dangerous thing to do. I mean, kind of trial advocacy 101. You don't ask questions you don't know the answer to, right? So it seems like a really bad idea to call an expert witness when you have absolutely no idea what they're going to do, but you do you, boo. And apparently it worked out. So I guess, okay, good for you, I guess. So what more do you want from me? I don't know. Okay.
Transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCO.
We don't know 100% what info the ARCO experts were presented with by the feds and camp based on work product. Well, anything they testify would be in their report, right? So it would be in their report. So yeah, I don't understand what's being held here. I'm confused.
Witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCO witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required.
Okay.
The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and insistent the best I can to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours.
Yeah.
That would have been nice to have. So my specialty...
So the thing that you didn't know, that you wish that you had known, is that most pedestrian collisions with cars occur at night. I mean, yeah, that seems to track. I mean, probably. If I were going to take a guess. I mean, you know, is it more likely the car runs into the pedestrian during the daylight hours or during nighttime? What is it more likely? Are you telling me it's more likely at the nighttime when it's dark outside? Oh, okay. What a strange revelation. Thank you for sharing this exciting information with me. I would have had no idea. Thank you for telling me. This is the bombshell information you didn't have. Okay. All right. Fine.
In the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
What? Don't tell them pedestrian injuries happen at
As an
night?
expert in court before, yes. I realize
You know
my
what?
testimony, I said.
I bet you, here's another one. I'm not an expert. I'm going to take a guess. I'm willing to bet that even more pedestrian injuries happen at night if it's overcast or if it's a new moon versus if it's a clear sky and a full moon. I'm also going to guess it happens more often if it's inclement weather. How am I doing? Am I doing okay? How am I doing how am I doing as an accident expert on this testimony? I think I'm doing all right. Okay. Okay. Good times.
20 times when you asked how many I've been qualified, I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925.
Okay.
That's not Trimble. That's not trial by ambush. That's getting duped. So, I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something.
We got ghosts now, baby. Cool. I didn't know we were going to bring ghosts into this case. Are we literally doing the skit from Family Guy where Peter Griffin calls to the stand the ghost that never lies. That'd be good. Well,
something's there and something's happening, a federal investigation, and this
it wasn't really a ghost. It was really Old Man Jenkins the whole time.
And then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
All right, please.
Exciting. All right, we will skip the recess. Okay. Well, we can't miss the OnlyFans content. So we will watch some OnlyFans content because you guys crave the OnlyFans content. Here are some hot OnlyFans content. I mean, the spinning is just, and the light show on the ceiling that you can see. Look at those stripes, man. Hot. Gonna need my fan myself with my hat. Whew. That's too exciting for me. All right, let's go ahead and we'll skip back to where we were. That's enough OnlyFans content for the moment. Back to the trial.
Back in session, you may be seated, make your cell phone off, put away.
I have to say this OnlyFans content is less salacious. I'm not really digging this, lol.
All right. So the Commonwealth just provided the court with information that causes me grave concern.
I bet it does.
The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So
wow.
I'll see you a week from today.
Judge is looks like we might lose the ARCA experts, baby. Look like we might lose the ARCA experts. Wow. Exciting. Fun. Jesus Christ. Okay.
At 11 o'clock in the morning, you can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
That does not. It would have to be at 9 o'clock in the morning.
We have to move.
Your Honor, if I may hand up the discovery
Thank you.
by the defendant reference by.
Oh, great, thank you.
Is there any way we should use this for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
Yeah, right. Yeah, right. I'm going to do this via Zoom. Give me a break. Not a chance.
I'd rather be here. But
Yeah.
I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live.
Me too.
I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
May I have just a moment?
Thank you.
Yeah, I don't want to do this hearing over Zoom. This is not pro forma, right? This is like a thing that I don't want to do this over Zoom. Personally, as a judge, I don't really want to do anything over Zoom, to be quite honest. I want to ban Zoom from my courtroom. That's what I want to do. I want to ban Zoom. No. We did trials just fine for a very, very, very long time without Zoom. Let's make trials great again.
Your Honor, we'll accommodate the 25th, one way or the other.
All right. So we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise to the court, please.
All right. All right, that brings us to the end of the hearing, so we got to talk a little bit about what just happened here. Okay, so ARCA, of course, was employed by the federal government as part of its interest in this case relating to potential federal charges or whatever. I mean, the federal government does what the federal government does. They had an interest in the case. They hired some people to help them look into this issue. ARCA was part of the people that they hired to help them look into the issue. Okay. Apparently the feds were like, this is such incredible BS that what's happened here, that we'll let the defense know that, you know, these experts exist and you can use them if you want to. Okay, fine. So the defense uses these experts, and we previously heard them testify about what they, you know, testified to about their accent and accent reconstruction. Okay. So of course, when the experts were under the employ of the federal government and the U.S. attorney, that's attorney work product, right? Because anything that they did is attorney work product and protected by privilege. Okay. So the question that's being presented here is, to what extent has ARCA relied on material that has not been disclosed to the prosecution? Okay. And it seems like it's not even necessarily 100% clear exactly what that is. Now, I think that there was enough disclosed here because the question is like, what models did they use? And right. So the question would be like, what data did you use? What models did you use? Like, you have to provide the basis for your opinion. I mean, you have to provide the basis for the expert opinion. So the question would be, what was the basis of your opinion? What materials did you use? And you can't say, well, that I'm not going to tell you. That's not a valid answer. So either you have to tell them, in which case the US government like waives its privilege or provides the material, or you have to give the people material independent of that they would then rely on. So to the extent that they could form their opinion based on information that you would, for example, obtain from the Commonwealth, then they might be able to give an expert opinion relating to that. It would be the same as hiring an expert relating to any case, right? So if I hired an expert, if I hired a dog bite expert or accident reconstruction expert, right? I hired an accident reconstruction expert, just in my personal capacity as a lawyer, okay? That conversation is privileged. It's protected. It's work product, it's privileged. Okay. Now, I obviously can't put them on the stand unless I provide the material that they used. So that, obviously waives my privilege, but I make that decision. And of course, in the case of ARCA, they never testified at a federal trial. It was all part of an investigation, right? So let's try to put this in an analogy that makes sense. Let's try to maybe try to take this out of the government context and put it into a different context and see if we can make it make sense. So let's say that there's a motor vehicle accident, okay? And there are multiple injured people, okay? Let's say that there are multiple people in both cars, all right? And there's multiple people that were injured, all right? Let's say I'm an attorney that's representing one of them, or even more than one of them, but not all of them, okay? I'm an attorney representing one of them or all of them, okay? And I hire an expert as an attorney to help me review the case, okay? And then I don't actually file anything in court, right? I'm just, you come to me, let's try a scenario, right? Let's try a scenario where this would make sense. All right. You engage me as a lawyer to represent you in a motor vehicle accident. Okay. You tell me all about the injuries that you suffered and all the rest of it. Okay. I'm your lawyer. You've hired me. We have a whole letter and everything. Okay. And so I'm doing my due diligence investigating your case. Okay. And one of the things I do to investigate your case is I hire an expert witness. Okay. I'm definitely billing you for this, by the way. So, prepare for that. I'm definitely billing you for this. I hire an expert witness to help me review the case. And this expert witness tells me that your story is bullshit. Okay. This is some bullshit. All right. So what am I going to do as a lawyer? Well, one of the things I might do as a lawyer is be like, I'm going to drop you. I'm going to drop your client. First of all, you owe me money. Second of all, I no longer represent you. Go away. Right? Because your claim is bullshit and I'm not taking it to court. Okay. All right, great. Now let's suppose that there's a case ongoing and I'm interested as a lawyer. Let's suppose there's a criminal case going on, because I'm not sure how this would work in a civil case. It would only really make sense if there's a criminal case. All right. So I'm a private attorney. I've hired an expert. This is some bullshit. Let's say that there's a criminal case ongoing, and this criminal case seems to be going in a way that seems adverse to what I determined as a lawyer, right? I determined that there's some bullshit, and basically the bullshit is now manifesting itself in court. Okay, I'm manifesting itself in court. All right, so I'm in a very weird position now under the finer points of rule 1.6, right? I'm in a very weird position with respect to rule 1.6 on what can I disclose and what can't I disclose as part of this and it's going to depend, interestingly, on state law, on the very exacting wording of 1.6. Okay, but under some 1.6, by the way, is the rules for secrecy for a lawyer. That's rule 1.6. But it's possible that I might be able to disclose some things to prevent like this manifest injustice, but I still have to maintain your confidence at the same time. All right. So maybe what I do is I go to like the defense lawyer and I'm like, hey, I just want to let you know that, I think that these experts might be able to help you. And they ask me, how do you know that? I'd be like, I had a case that concerns this matter. And I can't really tell you anything about it, but I can tell these experts were very helpful to me in deciding not to represent whatever, right? So, right, and they want to hire those experts, and because they think they might be helpful, right? Now, if those experts are now in court based on the investigation I did as a lawyer, right? And I don't want to waive my work product because, I represent you. I don't want to waive my work product. It's privileged. And also, I want to keep my disclosure as minimal as possible because it's secret. It's secrecy, right? So I don't want to give my work product. But if those lawyers were in court providing testimony based on the work product and I refuse to give the work product, yeah, the judge would exclude it. The judge would exclude it. But if those lawyers, if those witnesses, if those experts independently, right, were able to generate very similar looking reports, right, for this new lawyer who might be interested in that, and based on information that would be provided within the context of that case, and we're able to generate it completely differently, that would no longer be my work product. Now it would be their work product, right? Even though it's the same situation, right? Right? So I sort of understand where the judge is coming from. And it's the question in my mind as a lawyer, the question in my mind is, to what extent is ARCA testifying based on raw data or raw information or other things that have not been disclosed, wherein under the rules, they do have to disclose expert witness, expert reports, and all the rest of it, right? So I think there's a point to be had here, possibly. I think there's a point to be had here, maybe. It's a little bit hard to believe, though, that there's any situation here of unfair surprise. It's also hard to believe the ARCA experts couldn't just generate the same information using the data that's available from the Commonwealth. But that's some analysis. So someone in chat said, or apologize, someone in Discord dropped a tweet. Tony gave me this tweet. Thank you, by the way. Christina Rex, apparently on chat, said, I asked Alan Jackson outside court if he paid ARCA to testify. No, of course not. In court, prosecutor Hank Brennan read documents including alleged bill from ARCA to the defense for $24,000. That's getting duped, he told the judge. I don't know what that means. What does duped mean? I don't know. So, yeah. So there might be a point here to be had. There might be a point here to be had about whether or not the defense complied with its obligations to provide the basis of the report, including the basis of the pay. You think it means he faked the emails? I don't think he faked them. I'm not going to assume the prosecutor did that. That's low. I'm not going to assume that they faked the emails. Looks like Hank got anonymous emails and took them seriously. Maybe that's more likely. Somebody faked them. Yeah, that makes more sense. Yeah. I'm not following me at all. Okay. I'm sorry. All right. How do I explain this in a different way? How do I explain this in a different way? I'll keep it simple. In order for ARCA to testify, they have to provide the basis of their expert opinion. They have to provide the things they used to create that opinion. And it is not an acceptable answer to say work product, because you can't do that, right? So it's like the crime scene told you or something. So, you wouldn't want an expert in trial who's just like, I'm of the expert opinion that these are dog bite wounds. Well, how did you come to that opinion? I can't tell you. Did you examine the body? I can't tell you that either. Did photographs? I can't tell you whether I did that. Like, it doesn't make any sense, right? You have to be able to inquire about the basis and the background of their opinion and what evidence they used and so forth and so on. You can't keep the basis secret. And so the prosecution is saying that the basis of their opinion, or part of the basis of their opinion, is being kept secret by the federal government. Which the federal government can keep the secret. They can do that. The federal government can keep the secret. But then the defense can't use the experts because they won't provide the basis of their opinion. That seems to be what they're talking about. So, and they say that they've been surprised by certain things, and yeah. That's not what ARCA did or said in court. They were all available from the reports, and it's ridiculous. Well, I'm just trying to explain what's going on. I'm trying to explain what the prosecution's saying. And they obviously disclosed some things in court, but whether or not they disclosed everything they need to, whether or not some of it's still hidden, I don't know the answer to that question off the top of my head. I don't know if there's anything hidden still. So, yeah. I don't get why they can't bring in the Fed investigation, because the federal government won't let them. It's the federal government's privilege. That's the prosecution's argument. Right? The prosecution's argument is the federal government won't let them because it's the federal government's privilege, and they haven't waived it as the work product. So that's what's going on. Why is Bev so mad? Just exclude them? Well, I think Bev is mad because, if we're going to give the devil their due, right? If we're going to give the devil her due and try to analyze this from a legal framework, then if we assume that Bev has just been told things that she didn't know about certain things that were hidden, she might have felt like she was deceived in the first trial, right? So, imagine that you're a judge, right? And you let these witnesses testify in the first trial, and you're just now learning that information that was supposed to be disclosed was hidden. Well, that pissed me off as a judge. I'd be really pissed. I'd be extremely pissed, right? I'd be incredibly I'd be apoplectically pissed, right? If you basically tricked me into letting these expert witnesses testify, and I'm just finding out about now, I'd be unbelievably pissed. So it's like not only am I contemplating, excluding your experts, I'm contemplating sanctions and beatings. So that's the best interpretation of what's happening, right? The best interpretation of what's happening to explain the judge's behavior from a neutral position. The best explanation of what's happening is the judge just heard things in this motion that makes her believe that things that needed to be disclosed were not disclosed, and she might have been tricked into letting these witnesses testify. And that would piss me off incredibly. This is more BS from Bev. I don't know if it's BS or not. Right? I'm trying to look at this as fairly as I can to both sides. Right? And I don't know the answer to the question. It strikes me as odd. It strikes me as unlikely. It strikes me as improbable. But I don't necessarily think that it's necessarily impossible. And so, yeah. Invert videos and lost text are top okay, but keep on destroying the defense. Yeah. I mean, we try to adjudicate this one issue at a time on this channel, right? We try to adjudicate this one issue at a time as best as we can, as fair as we can. We want to be neutral. We want to get it right. We want to get it right without favor to either side. You guys know I think this case is bullshit. You guys think I know the prosecution is bullshit and the evidence sucks ass. You guys know that. It's like, I don't need to prove my bona fides over here. But I want to give you the fairest legal analysis I can. I'm like, okay, here's what they're talking about. Here's what's going on. Here's what the prosecution is saying. I was like, okay, this could make sense. Maybe. Yeah. I mean, it doesn't seem likely. It doesn't seem probable. It's not clear, like even in principle, what the defense could be, what the expert witnesses could be using as the basis of their opinion that the state wouldn't have access to. But, maybe. Yeah. It's a lot. Excluding these experts is a lot. It's a big deal. It's a big deal. But, do you want to get the law right? So maybe there's a case to be made. Maybe there's a case to be made here. If it were the other way around, I believe the defense would be doing the same thing, right? If these ARCA witnesses, right? Imagine like always, it's always helpful to imagine the counter scenario, right? It's always helpful to imagine the reverse scenario when you're like trying to make legal decisions, right? Because you want to be fair, right? So if you imagine that these ARCA witnesses had been like, you know what, we think Karen Read is guilty. We totally believe it. We've done our analysis. And the feds is like, you can borrow them, but we're not going to give you our work product, but you can borrow them. How pissed would the defense be if the defense didn't believe it had every piece of the basis of those expert witness opinion, right? If those expert witnesses were testifying on behalf of the government, and yep, we did the accident reconstruction science, we totes believe it's Karen Read. How pissed would the defense be if they felt like they didn't get part of the basis of their opinion, right? How pissed would they be if their report didn't provide all the things they relied on, if it wasn't complete, if they were hiding things, like with secrets and stuff, how pissed would the defense be? Extremely pissed, right? Extremely pissed. And so it makes sense. It makes sense. Maybe. I'm doubtful, but I don't think it's impossible. It's a bombshell? Yeah, it's a bit of a bombshell. Yeah. If the ARCA experts were testifying on behalf of the state, Aunt Bev wouldn't be clutching her pearls and having conniption. Yeah, that might well be true. Yeah, that may well be true. But, you know, the question is always whether or not you're doing the right legal decision, right? So, notwithstanding the fact that if they were testifying for the prosecution, I tend to agree with you that Aunt Bev probably would not care as much. That would just make her a bad judge, though. That would just make her a bad judge. And so, let's try to be good judges and try to get it right. So, yeah. Very interesting. Very interesting. Should we go back and re-listen to what he said about this? Should we listen to it again? Or are you guys satisfied with having heard it the first time and feel like you got it? I'm sorry my analogies were difficult to understand. I wasn't really satisfied with my own analogies. I was trying to explain this and I didn't feel like I did the best job ever. I apologize. I felt like I didn't necessarily make it as simple to understand as I was trying to. You want to listen to it again? Yeah, let's listen to it again. Let's listen to it again.
Your Honor said, see, I don't see that as being the report. I don't see that as...
So, Mr. Brennan? Sure.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, And it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed, and over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins and the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Material our vehicle is something that, so not being too. So we see in the margins and the notes, this fair-minded, objective witness says, so not being too.
Who's he talking to?
Witness of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins and the notes, this fair-minded, objective.
Where are these notes coming from? Did he say where the notes are coming from that he's reading right now? Was this turned over by the federal government?
Witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated.
Okay.
The TUI request is a recent February response.
All right, so it sounds like those notes are coming from the federal government. Okay. All right.
But they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in.
Is he saying that this request from the federal government, the answer to it came back after the first trial was over? Is he saying that it sounds like it, he personally put in the TUI request and he got this information? So this is new information? Okay. All right.
Who knows nobody. So we see in the margins and the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough.
Put somewhere in the direct examination. I'm not sure if you want to put this somewhere in the direct examination. It sounds like he's talking to Karen Reed's defense lawyers. I'm confused by that. Is this an email? This is an email with Jackson? I'm very confused. If this is an email with Jackson, how is he getting a copy of this? Well, then how is he getting a copy of it if it's an email with Jackson? That doesn't make sense. I'm very confused where he's getting it from. I have to go back, I guess. There's a clip of him posted in Runkle's Discord correcting he didn't get from the feds, but the defense. Got from the defense. Feds gave it to him in the TUI request. That doesn't make sense. How'd the feds get a copy of it? See how if it's an email with Jackson, how'd the feds get a copy of it? He gave the wrong year?
Discovery so that the experts could test. That's essentially it. We've spoken to them only for purpose. There has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed, and over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves.
So the defense, okay. So the defense is talking to the ARCA witnesses and the feds at the same time. And so that's how they got the emails. They got them from the feds. Okay.
A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required.
Okay.
The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward.
Okay.
Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes, absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question, my fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the
I'm still a little confused on like how he's getting these emails. I mean, is the federal government CC'd on these emails? Because otherwise, I don't know how he's getting these emails with Jackson. And also, by the way, that sounds pretty routine for an attorney, by the way. It doesn't sound nefarious at all. It's like, sounds pretty routine. So I'm confused how he's getting these emails. He got them from the defense? Why would the defense give them? That doesn't make any sense. Their work product. Why would the defense turn over these emails? Their work product. You would have to claw these emails out of my dead hands. You'd have to claw these emails out of my dead hands. We need to watch the rest of the video. There is no more arrest. She just comes back and she says that we're delaying the trial. There's nothing left to watch. We've watched everything. Hank goes back on the record. I mean, we can watch it when the judge comes back, I guess.
The court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th.
Why on God's earth would the defense provide those emails? I don't get it. That doesn't make any sense to me. I don't understand. I can't begin to contemplate why a defense attorney would do that, or why any attorney would do that under pretty much any circumstance. Why would the defense turn over the emails from the lawyer to ARCA? I don't get it. I don't understand.
2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
How is he getting copies of this from the defense? It doesn't seem like it was pure mistake, because there are rules for that, by the way. There are actually rules for that. Like if a lawyer accidentally discloses privileged material, there are rules for that to prevent that from being used. You can't accidentally waive privilege, right? So if I do a dumb, right, as an attorney, and I accidentally forward you an email, right, and that's privileged, there are rules for that, so I can claw that back, right? Because, you know, everyone makes mistakes, I guess. So there are rules for that, so I can claw that back. But they're not screaming mistake. They're not up here screaming this was a mistake, inadvertent disclosure, all the rest of it. They're not making that kind of argument. Defense isn't like standing on their feet saying this is inadvertent, this is, you know, a mistake. This seems like defense made this decision to do this. Okay, why? Why would you ever do that? I don't know. I don't understand. Make it make sense. Make it make sense. Yeah, I don't get it. When you're an expert, all the emails have the disclaimer? Of course they do. Of course they have the disclaimer. Every lawyer and attorney, every email a lawyer sends has the fucking disclaimer on it. We're not idiots. Yeah. We're not idiots. So I don't understand why the defense turned this email over. I also, incidentally, don't really understand what's nefarious about the email, except to the extent that there's this payment that was not disclosed. That's the only thing that's nefarious about it. Otherwise, the email's completely normal, right? It's like, just like here's something you might want to ask me about in your questions, or maybe you don't want to ask me this question. I mean, it's totally normal. All right. I mean, there's nothing untoward about the emails. So I still don't know why you would ever disclose them ever, but there's nothing untoward about that. You know, the defense and their expert are working together to figure out how to make the testimony as good as it can be. Shocker, right? Nothing nefarious there. It's like, maybe you don't want to mention this aspect. It's like, okay, maybe I won't ask that question because I don't want the answer to it. All right. It's like, I don't have to ask the question. I mean, you know, or maybe you do want to ask me this question because it's important. There's nothing nefarious about the emails. I still don't know for the life of me why you would ever turn them over ever. Yeah, it's completely standard expert prep. It's totally standard expert prep. No problem. Dark Tech Observer says, I think Brennan's entire attack here hedges on the mistake he made about the source. Mistake is about the first trial, not this one. Reporters that the $30,000 are for expenses. Well, if that wasn't disclosed, maybe that's the problem. I don't know. Yeah, I don't know. So the only thing that I think that is problematic based on what he said, the only thing that's problematic I can see is the fact that if they weren't paid and that wasn't disclosed. That's the only thing I can see that might be a problem. But so we'll go with it one step at a time. Yeah. We'll go with it one step at a time. Anyways, Karen Reed has appealed to the federal court for dismissal of her 2 charges. Not a chance in hell, by the way. Not happening. First of all, I don't think she has a claim. She's not being held, so I don't see how you can do a habeas. The issues relating to abstention doctrine, relating to live state level proceedings, feds won't get involved in a live state case. Not a chance in this world. Even on a double jeopardy issue, I don't think they're going to get involved. That's no. Plus, we've discussed this legally. I can't find any legal hook federally, so there's no precedent for this that would help the defense. So no. But they're gonna go to federal court anyway and be told to go to hell. I'm pretty sure the federal courts don't want to get involved. It's a live proceeding. I'll actually be slightly amazed. Odds are the federal court refuses to hear the case on abstention doctrine. They refuse to hear the case because it's an ongoing live proceeding. So odds on favorite, the federal court says we're not even going to hear the case. If they do hear the case, they're going to say no. So let's see how that goes, I guess. After the Massachusetts highest court were denied the request to have 2 charges dropped in her closely watched murder trial, she's filed an appeal in federal court, opening a new siege. Okay. Miss Reed is currently facing an April 1st retrial after prior mistrial. The petition contends that retrial would violate the 5th and 14th Amendments. They filed in the Massachusetts District Court, which sounds like they're trying to do a habeas proceeding, right? If you're filing in district court, it doesn't sound like you're appealing. You're trying to do a collateral, right? Because if this was an appeal, there's only one place to appeal to. That'd be the U.S. Supreme Court. So it sounds suspiciously like we're trying to do a habeas on a person who's not even being held. I don't know, man. That sounds problematic at best. I don't see that working. The motion was filed the same day Reed and her lawyers were back at the Superior Court for motions about the new trial. The defense has said several jurors revealed to them the jury was in agreement that Reed was not guilty of the charges. But last week, the Massachusetts Supreme Court ruled against them, upholding the lower court dismissal. Yeah, so we might at some point read that if I can find it. So I have to go diving in the federal docket for a copy of this petition. I wonder who it's even versus at that point. Who is it read versus at that point? I actually don't, or is it like in Ray? actually don't know how it's titled. That's interesting. How is it actually titled? I don't know. Yeah, how would you actually title this as a lawsuit? I'm actually not sure. Because it's read versus, well, who am I suing? I'm not actually sure. So is it in Ray? I don't know what it is. That's interesting. Well, we'll see how they styled it. It'll be fun. Yeah. Thank you for the citation, Dave. You're my hero. You can be my hero, baby. You can wash away the tears. You are my everything. Let's pull this real fast and see what the hell they're doing. Let's pull this real fast and see what they're doing. We'll speed read it. And if we need to do a full breakdown, we'll do that too. Let's see. Oh, hold on. If I do this, I might, okay, hold on one second. All right. I might lose you for just a second, but I'll be back. All right, I'm back. All right, that wasn't so scary, was it? All right, I know you were scared to not have me there for a full like 3 seconds, but all right, let's see. Massachusetts District Court. That's where I'd like to go, and I need to use my new password because you guys changed it on me. District Court is where I'd like to go. I'd like to query, please, for the case number. Run that query, please. Reed versus Norfolk County Superior Court. Okay. All right, I guess. Petition for a writ of habeas. Okay, we did style as a writ of habeas corpus. All right. Okay. Let's take a quick peek. I'm not reading 35 pages on stream right now, but let's take a quick peek and skim this. We know the procedural background. We know what happened. Double jeopardy. Blah, blah, blah. Okay. So here's our try to get around the abstention doctrine. Here's our try to get around that. The First Circuit has made clear a petition for habeas that raises a colorable claim of former jeopardy need not await trial and conviction. So, yeah, we're going to try to get around the abstention doctrine on this issue. Okay. I'm not sure it's really plausible, but fine. To realize the solemn promise, federal habeas will, in appropriate circumstances, entertain a claim that permits a nascent state court proceeding to go forward that would violate double jeopardy. All right, you're going to try to get around abstention doctrine. You know, good luck with that. You might be able to pull it off. We'll see. All right, let's see what else we got. We know the history. We know about the jurors. We know about the things. Standard of review. She's not in custody, and we know that. Court must defer to the findings of fact. Fine. Constitutional protection against double jeopardy. We understand. Double jeopardy clause. No manifest necessity. Blah, blah, blah. Blah, blah, blah. No. Fuck no. Right. The suddenness. They're still with the suddenness of the court's action. We were totes surprised. We were totes surprised by the judge. They're still trying to make that work, man. Come on. No, you weren't giving a break. Legal factual findings are even more expected. No. They're entitled to relying on a full opportunity to be heard. No. Blah, blah, blah. No. No. No judicial alternatives for the mistrial. Simply ask the jury. Well, the Supreme Court of Massachusetts told you why it doesn't want to do that. The judge may declare a mistrial, provide, however, the judge may, may. The reporter notes indicate it's required. I noticed that the notes say it's required, but the rule actually says it's discretionary. So the notes do not overcome the rule. That's bullshit. Plus, of course, Massachusetts is the judge of its own rules. The U.S. Supreme Court has zero power to challenge Massachusetts as to its own state level rules. So whatever this means in the notes is 100% a question of state law, period, end of question mark. Right? So yeah, the Supreme Court didn't go with that. So no, but I appreciate you trying to rely on state level rules like the Supreme Court of the state didn't tell you to go away. Okay. The Fifth Circuit held an analog. Okay, blah, blah, blah. Okay, you have some precedent relating to this where there was a situation with a jury of 11 people, which is legal in the federal system under the federal rules of procedure. So I'm not really sure it has to do with anything. Okay. Blah, blah, blah. Blah, blah, blah. No. What constitutes acquittal is not controlled by form. We've been down this road. No. 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 The Supreme Court's decision in Bluford is not to the contrary, as it's factually distinguishable. There, the foreperson had a report during deliberations. The jury was unanimous against the charge of capital murder, but split on manslaughter. The court sent the jury back. The Supreme Court rejected the defendant's argument double jeopardy prohibited re-prosecution. In doing so, the court relied heavily on the lack of finality. But this idea that this was final, here, by contrast, these statements reflect finality. Give me a break. No. Alternatively, we're entitled to a post-verdict. No. 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 I appreciate their enthusiasm, but no. I appreciate their enthusiasm, but no. Odds on favorite are the district court uses abstention doctrine and doesn't hear the case. I think that's still the odds on favorite, despite the language from the First Circuit that says that courts can do this. I don't think the court is going to go out of their way. Right. So I still think the odds on favorite are abstention doctrine. And even if they hear the case, just no. Just no. So I don't see any of those things happening. But I appreciate their enthusiasm. All right. Well, I suppose that will bring us to the end of the stream. Did you guys like the stream? I thought it was pretty good. We had some pretty interesting, complex legal analysis. Tried to really understand exactly what was going on here. And we'll see if what's happening relating to these payments and whether or not that's a problem. But, you know. If it was true that the defense had paid the expert and that information was not disclosed previously at the previous trial, then I'd get irritated too. as the judge. So we'll have to figure out whether or not it's true or not, but I can certainly understand the irritation. I can understand the irritation. You know, lawyers have to make honest representations to the court. You know, or lawyers aren't allowed to lie to the court. You know, or lawyers have to be, you know, candid to the tribunal. And so if the lawyers lied or even suborned perjury, then that would really piss me off a lot. So I can understand if there's some truth to this. So we'll have to figure out what's going on. So, but, well, I suppose we'll see in a week. We'll see in a week what's happening, and we'll try to get a little bit more information, and hopefully we'll be able to be in a better position to try to adjudicate this thing. But, you know, there seems to be something here, maybe, from the prosecution relating to the ARCA witnesses. Maybe. It's possible. So the judge wanted to have another hearing on it to explore it in more detail. Fair enough. Because it's potentially, you know, a big deal. I appreciate the taking the time to, you know, to like, let's try this a second time. I appreciate it. So, yeah. I believe the defense was looking to hire the experts for this trial. Yeah, maybe. Yeah, maybe. Maybe that's what the payment is relating to. Maybe that's what it's relating to. And if so, then, you know, fair enough. You know? So maybe that's exactly what it is. Could well be. Could well be. So we'll press one step at a time and try to figure out what's going on. Yeah. So I'm going to go ahead and sign off for now. We will be on later today, probably in about, well, I don't know, maybe a little bit later, maybe 3 o'clock my time, maybe 2 hours or so, maybe 3 hours. We'll be on with a little bit later relating to this interview with Turtle Boy and the juror, and we'll try to understand. We'll try to understand juries, which is always a mistake, right? That's a mistake. Don't try to understand juries. It's a fool's errand. But we're going to give it a go anyway. We're going to give it a goes anyway, and we'll have fun as we try to make sense of the juries, which is just fundamentally an error, but we're going to have fun trying anyway. I've been on Civil Law. Until later, my friends, I hope all's well. Is anyone streaming right now I can send you to? Who's streaming? Recovery Addict is streaming. Oh, Melanie Little's still streaming this. I'll send you over to Melanie Little's chat. Now, I will caution you just to be, please be nice to Melanie Little's chat, okay? Please be nice. Melanie Little and her chat, they really stan Karen Read hardcore. And so if I were to imagine their chat right now is basically saying, you know, the prosecution sucks balls and they have no case and this is a travesty of justice and so forth and so on. Okay. I'm not trying to stir up shit. Okay. I'm not trying to stir up shit. I'm just preparing you to let you know. Okay. So if you go there, be nice. Okay. Be nice. Don't be mean. Okay. And please don't stir up shit. Okay. We're just trying to show support to another channel, even if they disagree with me, which is okay. They're allowed to disagree with me. They're allowed to disagree with me. Please don't stir up shit. Please be nice. I've been on Civil Law. Till later, my friends. I hope all is well. Cheers for now, my friends, and goodbye.